begin. Is
You may be having an internet problem. You may start.
Yeah, thank you, sir.
Madam, go ahead, please.
Good evening, everybody. Respected guest speaker, Shri Bhagyodaya Mishra ji, beloved Principal Dinkar Gitte sir, my dear colleagues at KLE College of Law, Navi Mumbai, and all dear fellow learners. A very warm welcome to this fourth webinar series. Today's topic for discussion is the Prevention of Money Laundering Act 2002 scheme and trial proceeding. The flow of events for today is first, the session will be started as we have already started, which will be followed by Principal Sir's address, and later I will be moderator for the event, and I will introduce the guest, which will be followed by lecture by the guest and question and answer session, which with vote of thanks will be the last event for the day. So now I request our principal sir to address our chief guest and our participants. Sir, over to you.
Yeah. Thank you, Srividya madam.
Yes.
Good evening, one and all. I would like to welcome Shri Bhagyodaya Mishra ji, who is an advocate of Gujarat High Court as well as Supreme Court of India. And I welcome him on behalf of KLE Societies, KLE College of Law, Navi Mumbai. Welcome. And I also welcome all the participants to this webinar series. I welcome all of you, and before moving forward and handing over session to Srividya madam, I would like to thank management of KLE Law College, Dr. Prabhakar Koreji, who is the chairman of KLE Law College and who is a consistent source of inspiration to all of us. Shri Kavadgi Mat sir, MLC, Karnataka, GB, KLE Law College. So I hand over this session to Srividya madam now for the further proceedings. Madam, over to you. Thank you.
Yeah, thank you, sir.
And I would be joining all of you on YouTube. Thank you. Thank you.
Yeah, thank you, sir. Sir, Advocate Sir Bhagyodaya Mishra ji, before I hand over the session to you, I would put in my little effort to introduce yourself, your good self, to our participants for the day. Mr. Bhagyodaya Mishra ji is an advocate in Gujarat High Court and Supreme Court of India. Sir is a special public prosecutor in Enforcement Department, Government of India, and Anti-Corruption Special Public Prosecutor, Government of Gujarat. He has appeared in number of landmark judgments and has been in standing counsel for the matters of RBI, ONGC, IRTC, BIS, Allahabad Bank, the National Small Industries Corporation Limited, the Center for Entrepreneurship Development, the Shipping Corporation of India, Competition Commission of India, BSNL, IIM Kashipur, Heavy Engineering Corporation Limited, to name a few. There are many more. Sir, with this brief introduction, I request you to address our participants. Over to you, sir. Thank you.
Please. Yeah. Welcome to all of you. Good evening. Before starting the session, I share. Before starting the session, I just.
Sir, on your screen, there is a black color, tab-like thing.
That is there. It's come.
Yeah, fine, sir.
Yeah. Now, starting before the Provision of Money Laundering Act, I clear it. I clear to PMLA before starting the my. before starting the PMLA, I just clear that the PMLA enforcement director, how they come in the case. If any FIR has been lodged in the state, anywhere in India, or FIR has been lodged by the CBI, then afterward, enforcement director, the Prevention of Money Laundering Act come. Enforcement director at that time see his criteria, under which criteria it's come. Afterward, they will register in their record, and under section 2 and 3, they done the investigation. And section 4 is a punishment. Before that, I clear the concept that the participant know about it, what the PMLA, how the PMLA come in the case. The PMLA referred to the Prevention of Money Laundering Act 2002. The Prevention of Money Laundering Act 2002 come into the force with effect from the 1st July 2005. The Act was amended by the Prevention of Money Laundering Amendment Act 2009, 16/2009. The Act was further amended by the Prevention of Money Laundering Amendment Act 2012, which has been passed on 52/2013. The Act extended to the whole of India, including state of Jammu and Kashmir. The objection of Prevention of Money Laundering Act 2002 started in the framing of the Act. It is an act to prevent money laundering, and it is to provide for the confiscation of the property derived from or involved in the money laundering, and to punish these who commit the offense money laundering. Now, where this department has, which under it is, the Director of Enforce in the Department Revenue Ministry of Finance is responsible for the investigation the cases of the offense of money laundering under the provision of Money Laundering Act 2002, Financial Intelligence Unit India FIU IND under the Department of Revenue Ministry of Finance is the central national agency responsible for the receiving, processing, analyzing, and disseminating information relating to suspect financial transaction to enforcement agency and foreign FIU. Now, what is a money laundering? The goal of the large activity is to generate profit for an individual or a group. Money laundering is the processing of this criminal proceeding to discuss their illegal origin, illegal arms sales, smugglings, and other organized crime, including drugs, trafficking, and prostitution ring, can be generated huge amount of money embezzlement inside the trading delivery, and the computer fraud scheme can also be produced large profits and create the incentive of the illegitimate and ill-gotten gains through the money launderings. The money so generated is tainted and is to be nature of dirty money. Money laundering is the process of the conversion of such proceeding of crime, dirty money, to make it appear as legitimate money. In PMLA 2002, money laundering has been defined as any process of activity in connected with the in the proceeds of the crime, including in concealment, provision, accusation of use, the projecting of the claiming and its untainted property. How does the money laundering actually take place? The process of money laundering generally involved the following three stages. Placement. The money laundering who is holding the money generated from the criminal activity introduce the illegal funds. See, they use the illegal fund into the financial system, and this might be done by breaking up large amount of cash into less conspiracy similar sum, which are deposited directly into the bank, or by purging of the series of instruments such as check, bank draft, etc., which are then collected and deposited into one more account in another location. In this, what you want to say? If any money laundering is there, person is there, they don't want to do the fraud. He open one account, fraud account will be open. And then after 20, 30, 40 fraud account will be open different cities. And huge amount will be transaction to illegal all the accounts. This is what to say. In that, the PMLA comes. which has not been declared where the amount has become immediately, the amount has been devoted within a week or within 2 days, the amount has been distributed to all where, or same day it will be distributed that and it will come to the PMLA, and we have to inform to the bank also such transaction is there, please inform to the PMLA, so PMLA will take the action against this account. The second stage of money laundering is laying. Everything is the stage of the money laundering typically engaged in a series of continuous conversation of the movement of the funds, which is financial banking system by way of numbers of accounts to hit their true origin and the distance them from the criminal sources. Money laundering may be used various channels for movement of funds like a series of bank accounts, sometimes spread across the global, especially in this jurisdiction, which is do not be cooperated in the anti-money laundering investigation. Hawala money also become in that. This is telling that. Integration, having successful proceed is criminal profit through the first two stages, the money laundering, the lenders of that then moves to this third stage in which the fund reach the legitimate economics after getting the irrespectively mixed with the legitimate money earned through legal sources of income. Money lender might then choose the invest of fund into the real estate, business, venture, and luxury assets, etc., so that he can enjoy the lending money without any fair and law enforcement agency. The above three steps may be always follow each other. At the time, illegal money may be mixed with legitimate money, even prior to the placement in the financial system. In certain cases, rich businesses like causing, gambling, real estate, the proceed in crime may be invested without the entertaining the mainstream financial system at all. These all the things are there, which is telling about how the peoples are indulged in such type of crime, and which is registered before the CBI or registered before the state government. Then after when become the information from the FIR, then after section FIR, then after we registered the case and started under section 2 and 3, after confirmation we registered the case and it will go to the court. What has been international response for tracking money laundering? If any money is coming from abroad, how can we will do that? In response of monitoring concern over the laundering of the Financial Action Task Force, FATF of money laundering was established by the G7 summit in Paris in 1989 to develop the cooperation international response. One of the fast track of the FATF was to develop the recommendation which is set of the measure of national government should take to implement effective anti-money laundering program. India as an active member of FATF. What step have been taken by the government of India to tackle this menace of the money laundering? The government of India commit to tackle the menace of the money laundering and has always been part of the global effect in this direction. India is signatory to the following UN conventions which deal with the anti-money laundering, and financial of the tourism. International Convention of the Suppression of the Financial Tourism 1999, UN Convention Against Transaction, Organized Crime 2000, and UN Convention Against Corruption 2003. In pursuant to the political declaration adopted by the special session of the United Nations General Assembly UNGGSS held by 8 to 10 June 1990, in which the India is one of the signatories, calling upon the member state adopt the anti-money laundering legislation and program. The Parliament has been enacted the special law called the Prevention of Money Laundering Act 2002, PMLA 2002. This act has been sessionally amended by way of enlarging scope in 2002 on 1916/2009 by enactment of the Prevention of Money Laundering Amendment Act 2009. The act was further amended by the Prevention of Money Laundering Act Amendment Act 2012 on 15/2/2013. What is the Office of Money Laundering? Whoever directly or indirectly attempt to indulge or knowingly access to acknowledge the part of party or is actually involved in any process of activity connected with the proceeding of crime, including concealment, possession, accusation of use, any projecting or claiming it as unclaimed property shall be guilty and offense money laundering under section 3. It is telling that if suppose the person knows that he is doing the crime, illegally transaction has been made. He knows that the money is illegally come and transaction has been made, and which has been not been disclosed to anybody. When the police has been investigation and found that the money has been come by illegally, registered the case, and the PMLA has been come in that under Section 3, they done the investigation. What are the procedure of the crime? The procedure of crime is any property derived or obtained directly or indirectly by any person as a result of criminal activity relating to a scheduled offense or the value of any such property, Section 2(1)(u). See, the amount has come illegally and they have purchased the land, bungalow XYZ. By the source, the government has come to know that this illegal transaction has been made. Lump amount as income tax return has been submitted and XYZ, they know about it. Then afterward, when the ED come to know, then they will put the investigation after the FIR has been lodged. And when they have registered the case in their record and started the investigation, at the time Section 2(1)(u), it will become. What is a scheduled offense? Offense is stated in the schedule to the Provincial Money Laundering Act 2002, or the scheduled offense is term of Section 2(1)(5) of the Act. The scheduled offense are divided in part 1 and 2. The part 1 offense, scheduled offense has been listed 28 paragraph. Number of acts are there in that the PMLA has coming. If suppose Narcotic Act is also there, Army Act is also there, Pollution Control Act is also there, other acts are also be there in that the PMLA has coming in. Has a right to indulge in this case and run the investigation when they know about this case. 28 paragraphs is a comprehensive of the Indian Penal Code offense under narcotic drugs, physiotonic substance, offense under the Explosive Substance Act, offense under the Unlawful Activity Prevention Act, offense under the Arms Act, offense under the Wildlife Protection Act, office under the Immoral Traffic Prevention Act, office under the Prevention of the Corruption Act, office under the Explosive Act, office under the Anti-Quantism Art Treason Acts, etc. There are 26, 28, 29 acts are there in that we are also indulged in that. Deal with the trans-border crime and is a vital step of the tackling money laundering across the international boundaries. Period to 15th to February 2013, the date of the notification of the amendment carried out in the PMLA, scheduled office part scheduled office where the momentary rupees or 30 lakhs was relevant by the intendant investing on the office money laundering. However, all these scheduled office related to part B schedule have been included. Part A schedule with 52 consequently there is no money mandatory that should be investing under. Earlier the amount limit is less. Now it has been no limit for that. Any 500 crore, 1,000 crore, they done the investigation and they come to this. What is the periodic offense? Any schedule offense is a periodic offense. Schedule offense is called a predicate offense, and the occurrence of the same is the pre-request of the investigation into the Office Money Laundering Act. What are the major acts covered in the schedule? Indian Penal Code 1960, NDPS Act 1985, Unlawful Activity Prevention Act 1965, Prevention of Corruption Act 1988, Custom Act 1962, CB Act 1992, Copyright Act 1997, Trademark Act 1999, Information Technology Act 2000, Explosive Substance Act 1908, Wildlife Protection Act 1972, Passport Act 1967, Environment Protection Act 1986, Army Act 1959. Who investigates a periodic schedule offense? Periodic offenses are investigated by agencies such as police, customs, CB, NCB, and CBI, etc. under the respective act. Earlier, starting, I just clear that how can we come to the case when we get the knowledge? Who are the person who can file the FIR complaint? The offense investigators, CBI, police, CB, NCB, extra other activity, other may be done, then also we come. Especially this police or state, CBI will come, then main role is started. But the PMLA role is started. Who can investigate the case of money laundering? As per section 48 and 49 of the PMLA, the officer of the Directorate of the Enforcement has been given power to investigate the case of money laundering. The officer has also been authorized to initiate the proceeding for attachment of the property and to launch the prospectus of the designated special court for the office money laundering. What are the possible action which can be taken against person, property involved in the money laundering? The following action can be taken against the person involving the money laundering: attachment of the property under Section 5, seizing, freezing of the property, a record under Section 17 or Section 18. Property also include property of any kind used in the commission of the offense under PMLA 2002 of any scheduled offense. Person found any guilty of any offense of money laundering are punishable with the imprisonment with the term which shall be not be less than 3 years or may not be extended to 7 years, shall also be liable to fine under Section 4. When the scheduled offense committed is under the Narcotic and Physicotropic Substance Act 1985, the punishment shall be imprisonment for the term which shall not be less than 3 years, but which may be extended up to 10 years and shall also be liable to fine. The prosecution of the conviction of any legal judicial person is not contingent of any prosecution of the conviction of any individual. What are the power available to the investigation office under the Act? The investigation office has a power to provisionally attach any property derived to obtain directly or indirectly by any person or a result of criminal activity related to the scheduled offense of the value of the such properties. This any case has been registered by the police or CBI, then after that, we will become under Section 5, they will do this. To conduct survey of the place, Section 16. To conduct search of the building, place, vessel, vehicle of aircraft, seize, freeze, record and property, Section 17. To conduct the person search, Section 18. To arrest person accused of the committing the offense money laundering act, Section 19. To summons and record the statement of the person concerned, Section 50. I just give you the details of the example. Suppose any person is in jail and the PLA has gone to investigation them, taking the statement. Then we move to the court. We take the warrant, go to the police station, sentence it to the jail, and take them in the custody to show the warrant of the 1 day, 2 days. The court has passed the warrant. Sometime the court does not allow us, or our aim is only there only for 1 day. We take the statement. For them, we take the permission for the jail. The PMLA go take the permission from the court for the allow us to jail, and the court jail authority will be given the permission in the jail to take the statement. What are the power authority during the survey? The authority during the survey may place mark identification on the record inspected by him and make or cause of to be made extract of the copy therefrom. Make and investigate any property, check a verification by him and record a statement of any person present in the place of which may be useful or relevant to any proceeding under this Act, Section 60. What are the power of offense authority during search and seize? Authority may be enter any search any building, place, vessel, vehicle, or aircraft where he was reason to be suspect that such record of the proceed of the crime are kept. Break open the lock, any door, box, locker, safe, almirah, and other acceptable where key therefore not be available. Seize any record of the property found in the result of the search. Place mark of identification of such record properties are required to make and or cause to be made extract of the copy therefore. Make a note of an inventory of such record of the property. Examine an oath any person who is found to be in position of the control of any record and the property in respect to all matters relevant for this purpose, if any, under this Act. Under this Act. Okay. where it is not be practicable as to size and record of the property, the officer authorized to make an order to freeze such a property where property shall not be transferred to otherwise deal with the accept, deal with the accept and the period permission of the officer making such order, section 17. At the time of limit, नहीं देखोगे at the time of limit of the तो जल्दी जाओ at the time of the retention of the record of the property seized during the search and the siege, what is the time limit for continuation of the order of the freezing of the property record freezing during a search and seize? Search and seize. The property record may if seized, be retained or be frozen, may be continued to remain frozen for a period not exceed 180 days. If any property has been seized by the department, our law is telling that 180 days afterward we have to move to the higher authority, New Delhi, to take the further order for the property attachment order to continue. That MLA is doing the same thing. They're taking the 180 days earlier, they move to Appellate Authority, New Delhi. And afterward, in the period of time, they take the order. Sometimes the order not be given by the authority, or sometimes, most probably, PMLA get the order. Sometimes it will be properly not be presentation, or the court has been not be properly understand the subject. Basic thing, for the purpose, the wrong order has been passed. Such things are there. What are the right of the person being searched during the search? Where an authority is about to search any person, he shall, if such person so required, to take such person within a 24 hours to the nearest gazetted officer, superior in rank of him as or a magistrate. If the requisition is made, the authority shall not be detained the person for more than 24 hours period to taking him before the gazetted officer superior to the rank of him or magistrate referred to subsection. The gazetted officer or the magistrate will, before whom any such person is brought, shall, if he see for reasonable ground for the search, forthwith discharge for such person, otherwise shall be direct the search may be made. Search shall be made in the presence of the two or more persons. No female will be searched by any of one exempt in the female of section 18. What are the right of the person during arrest? What are the right of the person during arrest? The authority officer making arrest shall be as soon as may be informed to the arrestee of the ground of such arrest. Every person so arrest shall be 24 hours to take a judicial magistrate or metropolitan magistrate as the case may be having jurisdiction of section 19. See, the law is there within a, if suppose somebody is arrested, within 24 hours we have to produce before the court for taking the further custody or for the further proceeding. What are the power of authority regarding issue the summons, enforcing protection of the document and to give evidence EDs? The director, additional director, joint director, deputy director, assistant director of the director of enforcement, power to summon any person who attendance be considered necessary, where to give evidence or to produce any record during the court of any investigation or proceeding under this act. All persons so summoned are bound to be attended in person or through authorized agent. To such officer may be direct and any bound to state the truth upon any subject respectively which are examine or make a statement and produce such document as may be required. Such proceeding are be deemed to be judicial proceeding within the meaning of section 193, section 228 of the Indian Penal Code, 45 of 1960, section 50 is there in our MLA. Sometimes the PMLA enforcement actor facing the problem. Sometimes accused, suppose in Nirav Modi case and Malviya case, in that ED has gone to abroad also for the investigation purpose, for the statement purpose, for the details collecting for purpose. Such things have to be bound to move anywhere. ED is bound to move anywhere for the conducting the investigation and search related with the case. What is the time limit for the retention of the record impingement during the procedure of conducting the PMLA 2? Authority empowered to issue summons may be impounded and returned to the custody for such period as he may think fit, may record produced before him for any proceeding under this act, provided that an assistant director or deputy director cannot imprint any record without recording any reason for so doing. Retain in the custody such record for a period of exceeding 3 months without obtaining the previous approval of the director. Section 15. What are the presumption of interconnected transaction? Where money laundering involved 2 or more interconnected transaction and 1 or more such transaction is proved to be involved in money laundering, then the purpose of educating or confiscation of the trial offense of money laundering itself, unless otherwise proved to the satisfaction of the executive authority or the special court, we presume that the remaining transaction of the parts such interconnected transaction section 23, it will become under section 23 that this proceeding will be started. Whether statement record before the investigation office under the PMLA is admissible if it is under law? Yes. Whatever the statement has been taken, it is legally valid under section 52 and 53 as I stated. Yes, the statement record before the investigation officer under PMLA is admissible in Evidence Act in the court of such proceeding under section 52 and 53 of the Act of Judicial Proceeding within the meaning section of 193 of section 228 of IPC. What is the burden of the full any proceeding related to the proceeding crime under PMLA? In the case of person charging with the offense of money laundering under section 3, the authority or the court shall, unless be contrary, is proved, presume that such proceeding of the crime are involved in money laundering. Second, in the case of any person, the authority or court may presume that such proceeds of the crime are involved in the money laundering under section 24. What is the meaning of the term property in the Prevention of Money Laundering Act? Property means any property of exist of every description, whether corporeal or incorporeal, movable or immovable, tangible or intangible, and includes deeds and instruments, evidence, title to or interest in such property or assets wherever located. Further property includes property of any kind used in the commission of any offense under this act may be a scheduled offense under section 215. What is the attachment? Attachment means any prohibition of the transfer, conveyance, disposition, or movement of property can an order to issue under chapter 3 of this act section 220. What are the circumstances under which the property can be provisionally attached under PMLA? Generally, what the PMLA do when the investigation, as per the law, is there, as per the law, when the investigation, if any property is also there, we can attach PMLA, the ED will attach the property. Whether director of any officer not below the rank of deputy director, who can attach the property? Whether director of not any officer not below the rank of deputy director authorized to director to reason to believe the research belief of the recorded writing on the case basis of the matter in the position that any person in the position of any proceeding of the crime, such proceeding of the crime is likely to be concealed, transparent, or deal with any manner which may be result in frustrating any proceedings related to the configuration of the such proceeds of the crime may be by the order writing provision attachment property of the period not exceeding 180 days from the date of order such manner as may be prescribed. Sometime in the NCLT, we are facing the PED, we have attached the property before that the RP has been appointment or OL has been appointment. Then afterward, the consult authority has come. and challenging this that our right is first, our right is earlier. We have done the right has given the court. हमको court से order, हमको court से हमारा right है court से हमको ये लेने का, which is totally wrong. When our right is there, when we take in when PMLA has taken the proper attachment, before that, how the law is telling that if right earlier we have taken the attachment is there, then those who are taking the first attachment, the right is there. In NCLT, Calcutta, same order has been given in the other case, Calcutta NCLT. Such order is attachments shall be made unless in relation with the schedule offence, a report has been forwarded to a magistrate under section 173 of the Code of Criminal Procedure 1993, or a complaint has been filed by a person authorized to investigate the offence maintained in the schedule before a magistrate or a court taking cognizance of the schedule offence, as may be similar report or a complaint has been made or filed under the corresponding law of any other country. Further, any property may be attached if the director or any other officer not below the rank of deputy director authorized by him. The reason to believe, the reason for the such belief have to be recorded in writing or on the basis of the material in the position that if such property involved in the money laundering is not be attached immediately, the non-attachment of the property is likely to be frustrated if proceeding under this Act, Section 5. How long this order of the provisional attachment of property will be remain force? Every order of the provisional attachment shall be cases to have been effect after 180 days from the date of order. If no order has been passed by the adjudicating authority under the PMLA that the said property is involved in the money laundering, however, within said 180 days, if the adjudicating authority may an order record a finding that property is not involved in the money laundering, the order of the provisional attachment shall be case to have been effect from the date of such order adjudicating authority, section 5.3. Earlier, I have to tell you related the attachment of the property. 180 days before we move, the ED will move before the adjudicating authority for the further extension purpose of the attachment. If suppose the adjudicating authority does not think that this property is not related with the concerned accused, or is not related with the other accused, those who are in the PMLA, in the case of the PMLA. So the property can be released by the court by the order. Whether the person claiming of entitled to claim any interest in the enjoyment of involved property can enjoy the property during the period of provisional attachment, yes, section 5.4. If suppose any attachment is there, but under section 5.4, their right is there, they will stay there, but the attachment of the PMLA will be there. ED will be there. If anything you have to do, you want to sell the property or XYZ taking the loan from the property, they have to take the permission for the PMLA, but PMLA not to give any permission to attachment is there, so possibility is not be there. What is the remedy available to a aggregate person where the property is provisional attachment? It has been provided in the Act that before recording the finding that all or any of the property are involved in money laundering, the adjudicating authority has issued a surplus notice not less than 30 days to the aggregate person to this stage can submit his reply to attend the hearing before the adjudicating authority or present a defense, section 8. In this same thing telling 180 days of property attachment is there. So though accused whose property attachment or without attachment of without meaning of the attachment by the ED, if suppose the attachment wrong attachment has been there, they move before the court. 30 days time may be granted to issue the notice, reply, and then afterward argument is there, then order will be there. What will be happen to the adjudicating authority report the finding that all or any of the properties involve money laundering? Where the adjudicating authority decided that any property is involved in the money laundering, he shall be an order in writing to confirm the attachment of the property's attachment shall shall continue during the pendency of the proceeding relating to any offence under this Act. Under this Act, before a court or under a corresponding law of any other country before the competent court or a criminal jurisdiction outside India as case may be, become final after a order of the confiscation is passed under Section 8(3). Suppose in some international cases there was intellectual property are there for the purpose also the MLA has a right to move and under Section 8(3). What will happen if the educated authority record the finding that all or any of the attachment seized frozen property are not involved in the money laundering? In such case, the educated authority shall direct to release all the property after then the property involved money laundering. The person whom the such property they seize or the person entitled to receive it under Section 25. However, the director of any other officer authorized by him in this behalf may be withheld and release any such property or a period of 90 days if the data enforcement opinion is such property is relevant for the appeal proceeding under this Act. 6. If any order has been filed within 90 days, have to be released by the PML, by the enforcement director. If any order has been passed by the appellant authority. What happened to the seized frozen record after the confiscation of the property involved in the money laundering or used by the commission of the offence of the money laundering under Section 8 of the PML? After an order of the confiscation of the properties under Section 8 has been passed, the educated authority shall direct the release of the record to the person from whom such record was seized. However, the director of any other officer, any officers authorized by him in this behalf may be withheld the release of any such record for a period of 90 days if he direct enforcement of the opinion that such property is relevant for the appeal proceeding under this Act of Section 21A. If suppose appeal authority has said that the property is not related with that, but ED has no property related with the same accused and the court has not been, we not get the justice. We will go before the higher court for the 90 days time in period, we will go before the higher, ED will move before the higher court. What will happen to attach the property after the conclusion of trial and offence of money laundering? We will give it to the government. I will come to know. I will clear you. Whereas the conclusion of trial of the offence under this Act, special court find that the offence of money laundering has been committed. It shall be such that such property involved in the money laundering which has been used in the commission of the offence of the money laundering shall be stand confiscated to the central government. Wherein concludes the trial under this Act, a special court find that the offence of money laundering has not been taken place of the party not involved in the money laundering, it can be ordered released to such property the person is entitled to receive it. Where trial court under this where the trial under this Act cannot be conducted by reason of death of the accused or the accused having been declared or proclaimed offended of any such reason of having commercial but could not be concluded, a special court as an application moved by the director of the person claiming to be entitled to possession of the property in the respect of which an order has been issued by the educated authority confirming the provision or attachment of the property, pass appropriate order regarding the confiscation release of the property as case may be after the having regarded material before subsection 567 section 8. I think it will be clear. Clear it like that. If not be clear, afterward you can ask me, I can clear. After the order configuration, all the rights and the title of such property shall vest activity in the central government free from all encumbrances, section 9. What is the appellate authority against the order passed by the adjudicating authority? What is the time limit of filed application? Director or any person elevated by the order made by adjudicating authority under this Act may be preferred to appeal of the appellate authority tribunal. Appeal has to be filed within a period of 45 days from the date of receipt of a copy of the order made by the adjudicating authority. Appellate tribunal may be entertained and appeal after the expiry of the period of the 45 days. It is satisfied that there is sufficient cause to not be filing within that period, section 20. Earlier, I discussed this matter, this point. which is the appellate authority against the order passed by the appellate authority, and what is the time limit to file the appeal. Any person aggravate any decision made order of the appellate tribunals and may be filed an appeal of the High Court within 60 days from the date of the communication of the decision order of the appellate authority to him, or any question of law, the fact arising out of such order, this appeal can be filed before the High Court of any question of the law and fact. High Court may, if it is satisfied that the appellant was a prevented sufficient cause of the filing the appeal within a set period, allow him to file within a period not exceeding 60 days, section 62. If suppose an appellant authority pass the order in the behalf of the enforcement director, for purpose, appellant authority afterward accused saying that the property is not we not get the justified, then they go before the High Court. I mean, High Court within a 60 days, you have to file before the High Court. How do you describe the expensive person appearing in the Prevention Money Laundering Act 2002? Person include an individual, Hindu undivided family, a company, a firm. These all are when the statement has been called for any company or person party, those who are accused in the other cases. For their purpose, these points are there which is be applicable at that time. Person include individual or Hindu undivided family, a company, a firm, an associate of person or a body of the individual, where incorporate or not, every artificial judicial person not failing within any of the proceeding subclause, any agency, office, or brand are owned by the control by any of this above, person maintained in the proceeding subclause. Those besides the natural person, every legal entity, and also covered under the expression person of the Act, section 2 also. What is the offense of cross-border implications? Cross-border implications. Any conducted by the person at the place outside India, which constitute an offense at that place, and which could have been constitute an offense, especially Part A and Part C of the schedule, said has been committed in India, and is such person transferred in any manner the proceeds in such conduct of part thereof to India. Thereafter to India, any offense specified Part A and Part C of the schedule which has been committed in the India, and the proceed of the crime or the part of thereof has been transferred to the place outside India, or any attempt has been made to transfer the proceed of crime a part thereof from India to place outside India, section 2(1). If suppose any crime has been made in abroad also, if a crime in India also, matter will be conducted here. If suppose any crime has been made in abroad, the matter will be conducted there. That accused refusal of numbers is there. Here in India, then accused to come in India. Now the Banking and Company Financial Institute of India. What are the reporting entitles? Reporting entries means a banking company, financial institute, intermediary, or a person carrying a designated business or profession, section 2(1) WA. What are the covered within this expression, person carrying a designation business or profession? Person carrying designation business person means a person carrying an activity for playing games, a chance of cash or kind, and including such activity associated with the casino. A registrar or sub-registrar appointment under Section 6 of the Registration Act 1908 as may be entitled to central government. Real estate agent as may be notified by the central government. Dealer in precious metal, precious stones, and other high value goods as may be notified by the central government. Person engaged in the safekeeping and administration of the cash and liquid security on behalf of other person as may be notified the central government. Person carrying of such other activity as the central government may by the notification to designation from the time to time under section 2(1) SA. What are the obligations of the reporting entity of the terms of the provision of PMLA section 2? Every reporting entity have to maintain record of the all transfers as per the nature and value of the such may be prescribed in the such manner as to be enable it to reconsider individual transaction. There shall be furnished to the director FIU within a such time as may be prescribed information relating to such transaction where the attempt and excluded in the root nature of the value of the may be prescribed. They shall have to verify the identity of its client and such manner as be subject to such condition as may be prescribed. They shall be identify the such benefits honor if any of any such of the client as may be described. They shall maintain record of the document evidence identify of its clients and benefit owner as well as the account file and the business correspondence related to the client for a period of 5 years in case of record and information related to transaction. They shall be maintained the same for the period of 5 years and business relationship between the client and the reporting entity has intended the account has to be closed within whereas later section 12. That the direction has been telling that what are the terms and what were the if suppose any accounts has been there, transaction has been there, we had how to we will keep 5 years after detail 5 years of the details we will collect department have to collect for the investigation purpose for the record purpose. What are the mandatory penalty that can be imposed on reporting entity for the non-maintenance of record and non-submission of the aforesaid information? If the information has been demanded by the PMLA, Enforcement Directorate, which has not been satisfied by the accused, that does not intend to submit the details. In the which section that will take the Enforcement Directorate will take the action. Mandatory penalty can be imposed on defaulting reporting entity of a diminution, director of the board of the employers, which shall not be less than 10,000 rupees, may be extended to 1 lakh rupees or each and failure. Section 13(2)(d). What is the applicant authority against the order passed by the DO? Any reporting entity agree by any order of the director, if you made under subsection 2 of section 13, made before appeal of the applicant to section 26. Special court. See, all over India, there are this from the ministry and from the High Court. They have appointment everywhere, every state, one designation special court for the PMLA. In Gujarat, in Ahmedabad district, principal judge has been appointed as the PMLA conduct purpose. In such a way, all over India, different position has been given to the consult court. Delhi also, the Patiala court has been given the Patiala court has given the jurisdiction for the Bombay also. Other court has given that action in such a way. For the trial and offence punishment under Section 4 of the PMLA, central government in the constitution, which with the Chief Justice of the respective High Court by notification has been designated by one or more court or session court, special court or special court for such area of such cases or classes or group cases are specified in the notification. While trying an offence of the money laundering under PMLA to the special court has also to try an offence within which the accused may be under the Code of Criminal Procedure 1973 of 1974, which charged with the same trial section 43. See, in the 43 and 44, the matter has been filed before the court. And section 4 is be there. In the trial proceeding, the IPC proceeding, CRPC will be followed. How the court will be trial will be there. And the matter has been filed by the enforcement department. Draft charge have to be submitted. Court will pass draft charge. A charge frame will be there. Then after, the department will be introduced their witnesses. Then after IO, other side will take the cross and final argument and order. What are the offence travel by the special code under the PMLA, notwithstanding contained in the Code of Criminal Proceedings, 1973, 2 of as an offense of money laundering punishment under Section 4 of the PMLA. 2 of any scheduled offense connected with the offense money laundering shall be liable with the same special code of this area where the offense has been committed. What will happen if the court which has been cognizant of the scheduled offense of other than the special code under PMLA which has been taken cognizance of the complaint of the offense money laundering? In this, I'll tell you, under Section 44(1)(c), the act is there. Act is been, see, if act is there, nobody will be challenged. Nobody can be changed up to Supreme Court. Sometimes what happens, if any 44(1)(c) application has been filed in the Baroda or Surat, some other places, and wrong case has been filed in the High Court, wrong details has been given, interpretation the subject of how the Section 44(1)(c) will be changed. Act may be changed sometime. The power of the Supreme Court, High Court to change the act, no power is there. They interpretation the subject before the High Court and take the wrong order sometime in these cases. But it is totally wrong. Under Section 41(1)(c), instances of the applicant by the authority authorized to file a complaint under PMLA, the trial court which has been cognizant of the scheduled offense shall have the commit the case related to the scheduled offense, special court under the PMLA. The special court PMLA on the registry of such case commit to it shall be proceed to deal with the from the stage and when the committed Section 41(c). 41(1)(c) is there. If suppose any case is filed by CBI or anti-corruption department or other department, by the state government, and the case has been registered in the PM enforcement department, also PMLA in court. So matter will be filed under Section 41(c) to consult city, and after given the application and get the order, and that matter will be conducted same proceeding from where the matter has been. Suppose trial is conducting there, the same stage the matter will be conducted in the PMLA court in trial stage. Same proceeding will be there. 44(1)(c) is telling us. 45. What is the appellate authority against the order passed by the special court? The High Court may be exercised so far as may be applicable all the power conferred by the Chapter 29 or the Chapter 30 of the Code of Criminal Procedure 1973 to a High Court or a special court with a local limit or jurisdiction of the High Court where the court of the session trying the case with the local limit of the jurisdiction of the High Court, Section 47. Regarding the filing of the challenge with the court. Reciprocal arrangement of the system is a certain matter of the procedure for the attachment of confessor property. What does it mean by the term contracting state? Contracting state means any country or place outside India in respect with the arrangement has been a ban, has been made by the central government with the government such countries through the treaty or otherwise Section 55. What is the mechanism of the obtained evidence required to connect it with the investigation into the offense proceeding under the Act if such evidence may be available in any place in contracting state? An application is to be made to the special court by the investigation officer or any officer superiorly ranked to the investigation officer, and the special court of being satisfied may issue a letter or request to the court or an authorized in the contracting state competent to deal with such request, examine fact and circumstance of the case, take such step as the special court may be special in such a letter or request and forwarded to all the evidence so taken or compiled to the special court issuing such letter or the request. Every statement recorded or document of the thing received from a contracting state shall be deemed to be the evidence collected during the course of investigation. Section 57. What is the mechanism to provide assistance of the contracting state? Where a letter of request is received by the central government from the court or authority in a contracting state requesting of the investigation in the offense proceeding under PMLA and the forwarding to such court authorize any evidence collected. Therefore, the central government may forward such letter request to the special court to any authority under the Act executing such request. Section 58. Where the property involved laundering location in India can be confiscated where the offense of money laundering has been committed outside India. The property involved in the money laundering located in India where the offense of money laundering has been committed outside India can be ordered to be confiscated to the Special Court Executive Authority of an applied move to Special Court Executive Authority Section 58B and 62A. What are the reciprocal arrangement of the proceeding assistant of the transaction accused person? Special Court of the relievement of the offense punishment under Section 4 of the service of the execution of a summons. The warrant of the search warrant is a contracting state shall be sent such summons or warrant in the duplicate in the prescribed form to the court, judge or magistrate through specific authority. Similarly, a summons, a warrant or a search warrant is related to an offense. Punishment under Section 4 received for service for or execution from a contracting state shall be served execution if it where the summons or warrant received. Receive it is where the summons or warrant received to it from the another court or set criteria of such execution. If summons has been issued by the other court and the matter will be here, then Section 4 is there, which will take the proceeding will be there and the court will be further proceeding. After summons, search warrant will be received by the contracting state and the document and other thing produced things found during the search and shall be forwarded to the court issue the summons search for the special authority Section 59. Whether the property involved in money laundering and located in the contracting state can also be attached the C? Yes, it will be attached. In such a case, officer, after the issue an order for the attachment of any property made under Section 5 of the treaty under Section 17(1)(a) or confirmation of attachment by the executing authority under Section 8 of the configuration of special court under Section 8 of the special court of an appellant or the director of any admission may be issue a letter or request to a court of the or an authority in the contracting state for the execution of such order as court as per the provision of the corresponding of the law under Section 61A. Still yes. What is the punishment on the accident research? Imprisonment for the term which may be now Section 2 years, the fine which may be extended to 50,000 rupees and both Section 62. What is the punishment against false information, failure to give the information? If suppose wrong information has been given to the department from the enforcement department, any person willfully and illegally giving the false information for the causing an arrest of the search are to be made under this act, shall and conviction to be liable for the imprisonment for the term which may be extended 2 years or with a fine which may be extended to 50,000 rupees or both Section 63(1). What is a punishment if a person being legally bound to the state and the truth of any matter refuse to answer any question put to him, refuse to sign any statement made by him, or omit to attend the produced book on account document at the place time the compliance the summons has been issued Section 50 is very important. See, penalty. If some which may be shall not be less than 500 rupees, which may be extended to 10,000 rupees for such default or failure to be imposed. Further, a person who has been intended to disobedience and a direction issued by under Section 50 shall be liable to be proceed against under Section 174 Indian Penal Code 1960, Section 1674. If any summons has been come, still any accused is there, and investigation is going on against him, and ED is demanding, Enforcement Act is demanding to take the investigation, further investigation, and to call him for the issue the summons calling him under Section 50. Issue the summons to calling him, but he doesn't want to come before the PMLA. Enforcement section will be liable for the punishment to him. Where the suit can be brought, a civil court set aside the modify any proceeding taken made under PMLA. No, the civil court has no jurisdiction in the such matter. No court can be brought, any civil court set aside the modify any proceeding take order modify under PMLA court. No prosecution suit or other proceeding shall be lie against or any officer of the government are done by intended of failure of the PMLA section 66. What is the mechanism of the recovery of the fine or the penalty imposed on any person under Section 13 or Section 63? Where any fine imposed any person under Section 13 or Section 3 not paid within 6 months from the date of impose a fine penalty, Director of India of the Enforcement or any other officer authorized by them in this behalf may proceed. to recover the amount from the said person in the same manner as may be prescribed Schedule 2 of the Income Tax Act 1961, 40 and 960 for the recovery of the arrears, and any officer authorized by him in this behalf shall have all the powers of the tax recovery officer maintain the said schedule of the said offense section 16. You can take the other, it will take the other procedure of the income tax department, also other department also. What is the provision where the office money laundering can be committed in the company? Where the person committed a contravention of any provision of this act or of any rule, direction of the order made there under the company, every person who at the time of the contravention who committed and take charge of and was responsible to the company for the conduct of any business of the company as well as the company shall be deemed to be guilty of the contravention of and shall be liable to be proceeded against the punishment accordingly. Provided that nothing contained in this subsection shall be rendered any such person liable to punishment if the person has to be contravention placed without the knowledge and that it will exercise all the deligency or the payment of such contravention. Notwithstanding anything contained in the subsection 1 where the contravention any of the provision of this act or any rule, direction or the order made by thereunder has been committed in the company, and to prove that the contravention has been taken place with the consent of the consequences of the attitude or any neglect of the part of the direction management, the secretary of any officer, and maybe company such direction management officer shall also be deemed to be guilty of the contravention, such shall be liable to proceed against the punishment. If any wrong information has been given and it is not be complied by the company, so punishment will be there. Further, the company may be prosecuted for demonstrating whether the prosecution of the conviction and legal person shall be continued of the prosecution to the conviction individually. If any person is company not being as a legal judicial person shall be considered of the prosecution under section 70. What is to happen if the conflict between the provision PMLA 2000 Act law? The provision of the PMLA to have the rewriting effect of presenting anything is constituted within the continental law, time being in force, section 71. What will be happen to the proceeding intimated under PMLA 2 in the event of the deal insolvency of the person? In case of where any property of the person has been attached under section 8 and no appeal against the order attached, such property has been preferred than the legal representative of the officer assigned of the office received may be prefer appeal to appellate authority high court and to continue to appeal before the appellate authority high court of place such as the section 72. Now there are the number of acts are there that I will only show you the name, but I don't know read the sections. Number of sections are there, more than 100 sections are there. So this will take time is not be there, so I can only read lines, and the PDF will be supplied to all of you. Then you can go through in your home. And office under Indian Penal Code 1960, 45 to 1980. Then office under Narcotic Drugs Physical Substance Act 1985, 61, 1985. Office under Explosive Substance Act 1908, 1908. Office under Law of Activity Prevention Act 1967, bracket 37, 1967. Office under Arm Act 1959. Office under Wildlife Act Provision Act 1972. Office under the Immoral Traffic Prevention Act 1965. Office under Provincial Corruption Act 1988, bracket 49 of 69. Office under the Explosive Act 1988. Office under the Antiquity and Arts Treasury Act 1972. Office under Security and Exchange Board of India Act 1992. Office under the Custom Act 1962. Office under the Bonded Labor System Abolition Act 1976. Office under Child Labor Provident Regulation Act 1986. Office under the Transportation Human Organic Act 1994. Office under Juvenile Justice Care Protection Child Act 2000. Office under Emergency Act 1983. Office under Passport Act 1967. Office under Foreign Act 1949. Office under Copyright Act 1957. Office under Trademark Act 1999, Office under Office under Information Technology Act 2000, Office under Biological Diversity Act 2000, Office under Protection of Plant Varieties and Farming Right Act 2001, Office under Environment Protection Act 1986, Office under Water Provision and Control and Pollution Act 1974, Office under the Air Prevention and Control Pollution Act 1981, Office under the Supervision and Unlawful Act Against the Safety, Maritime Navigation and Fixed Platform and Content Set Act 1902. These are the acts are in the ED, which ED can be take action against them if suppose any FIR has been registered or any complaint has been filed by the CBI or any other organization where we file the complaint against police. Now the judgments are there. Deepak Talwar judgments are there. Talwar is a corporate layout who was the detention to UOP and the arrest ED. June 2019, it is involved in the case of misusing over 19 crore taken through the foreign funding route as part of the corporate social responsibility CSR. He has other section of the FCRA for allegation diverting 19.72 crore with the foreign fund meant and the ambulance other the articles received by NGO from Europe leading missile manufacturing company. Augusta Westland. Gautam Khaitan, arrested by Khaitan, accused receiving the kickback of the 3,600 crore defense deal by the Italian chapter manufacturing against the Westwood Land for section AW1 copper during the UA to the 2010. The investigation has been revealed the nexus between the Khaitan and the Bandra family of the Zimbabwe agreed that the exit link between the accused with a very armed dealing and deals. ICC Bank. ED has registered the criminal case money laundering against former ICC Bank CEO Chandra Kachar, their husband Deepak Kachar, Videocon Group promoter Venugopal Dutt and other people prove allegation and corruption practices sanctioned rupees 111 crores 87 loans by the bank. Corporate group ED carries out the searching of March 4, 19 against the Chandra Kachar Videocon Group promoter Venugopal Dutt and few other connected with the bank loan fund cases. ED has registered the case under PMLA on the basis of investigating the Central Bureau investigation in the matter. CBI named Chandra Kochar, Deepak Kochar and Dawood among other allegations in the note. Vijay Mallya. Special Anti-Money Laundering Court confirmed and the order attachment assets of the 1,411 crore issued by the ED against the UBHL and other connected with the money laundering proof against the liquor bearer Vijay Mallya and other. The total attachment made by the agency in this case now showed at the 80,041 crore and one of the larger attachment asset made by ED and the PMLA case still now further investigation going. In that, the ED has moved to the super foreign also in this case. Chhagan Bhojpal, former Deputy Chief Minister of the Arrest and March Enforcement of the allegation money laundering case in which the agency claimed that he has been was to lose 870 crore in the execution. He challenges Section 19 and 40 of PMLA. Section 19 empower ED to arrested and accused based on evidence gathering by the agency against the individual, while the Section 40 deal with the bail accused. Nilesh Tarachand Saab. The derogation provision Section 41, the provision of Money Laundering Act 2002. Insofar as the imposing two conditions for releasing an accused on the bail, he had to be unconstitutional in violation Article 40 and 21 of the Constitution, landmark judgment of the landmark judgment of the Supreme Court of Nikhil Tarachand Union of India, Irrigation Diamond Sri Charan Damor, Sri Damor, Kanjan Group manager of the Rona Karmata property arrested ED June 2019, helping three companies landed to 2,000 crore Hong Kong money apex 2,000 crore was illegally landed by using fake import document. Three companies, further Sri Charapara government and the Kankara Gram and the managing deposit large amount of money society account using facilitated name before the reduce them in the society bank account. The money will be later a transaction of the RJC and the Nirav Modi has been charged with allegation that the company linked with him in his relative had a credit of 30,500 crore between 2011-17 using the false later undertaking LOC allegation is the bank official board ready about a branch following the FIR has been filed by the RBI by the PNB with the CBI in the last week of January 18th. It would have to begin investigation against the Modi, and from mid-February onward, under the provision of Money Laundering Act, to the notice of the operating used by the Swift network and the bank official issued the locus on the behalf of the company linked with Nirav Modi Group, including the solar experts, Diamond are used buying a credit from the overseas branches of Indian Bank. The transaction are deleted through the core of the banking system, avoid fraud and action. So far as the case, ED has been attached to probably 1,712 crore in India and abroad, actually gold, diamond, bullion, jewelries. Other valuable worth of 30 crore has been seized. Recently, attachment into Royal real estate jewelry and high value of the worth of 147 crore. Other judgments are there. Mikul Choksi, related with the Nirav Modi. In that they have gone to, the department will go to abroad also for further investigation purpose. Sri Ganesh Jewelry House, gold, then after Super Organic Limited, University Pamela, then after Supeak Asia Online Private Limited, Alchemistic Info DLT Limited, then IBC versus Pamela. That's all. Thank you. I hope everybody enjoyed this session. Enforcement department is that department which has been very sensitive cases are there in all over India, and sometimes they have illegally harassment also been given by the other peoples. Those unauthorized peoples are there. Thank you very much for the college to giving me a chance to tell you the students of the college to get the information, and other participants, junior lawyers and other also enjoying. I hope if any queries is there, any question is there, please tell me so I can help you.
Yeah, sure, sir. Thank you very much, Advocate Mishra, sir, for such a comprehensive coverage of the topic. There seems to be no room for any doubt, though. Still, for the benefit of participants, and owing to the paucity of time, I apologize.
Madam, voice is little bit less. Can you soundly speak a little bit more loudly? Can you speak more loudly?
A humble request to you, sir, kindly put your presentation off, the screen sharing. Can you please off that, because we can see the just slide on the screen.
Let me understand, madam. Voice is not be clear.
Sir, am I audible?
Yeah, audible, but your voice is not be clear, madam. Can you speak loudly, madam, so I can understand what you want to say?
Yes, sir. Yes, sir. Sir,
please,
first of all, thank you very much for the comprehensive coverage of the topic. There seems to be no room for any doubt, though, but still for the benefit of our participants, and I will be taking only one or two questions. My apologies for participants because of paucity of the time. I'm constrained, and one more before I take a few questions. One instruction I want to pass on to our participants: kindly refrain from exhibiting foul or smittiness on the questions while you are putting. Please refrain yourself from exhibiting such language. It's my request. And sir, with your permission, now I'll take a few questions, one or two questions, sir. Just 1 second. Yeah.
Please, madam, please.
So one question from Deepak: what is the conviction rate under the cases booked under PMLA Act?
See, number of cases has been registered in the PMLA all over India. In the pipeline, number of cases there which has been investigation going on. Other, I don't know, because I am only a special PP of Enforcement Directorate. So I know that that other cases are there in line. A number of cases are filing all over India.
Oh, okay, sir. Thanks for your answer.
Please, madam.
Sir, there's another question: whether there is any method to find out the score of anti-money laundering in other countries?
Yeah, it is there. The foreign also is hosting. See, in Nirav Modi case and Malviya case, the enforcement director had taken help of the CBI. They went to the abroad also for the further investigation purpose. They tie up with the foreign organization. Our agreements also with them. I tell in the webinar, I detail about it that we are a member of another member of the organization. In that we take the help related with any issue will be there. Such thing is there.
Yeah, thank you, sir. Sir, there is one question from Dr. Raju from Banaras Hindu University, Varanasi. When every account is connected to Aadhaar and PAN number, how is it possible to open a fake account? And how we can ensure validity or identity of account holders?
See, I'll give you the example. One case has been registered in Harfoj Patta of the Gujarat case. In that, one person is there. He has made a false accounts. Aadhaar card is there. Everything will be there. Legally, account has been opened. But when the transaction has been made, wrong, totally illegally. Suppose the account has been, 50 account has been opened, 10 account has been opened. But the transaction has been made illegally. Suppose 10 lakh rupees has been debited immediately within a 15 minutes, 10 lakhs are deposited there. 1 crore has been taken and immediately to deposit some other places. In this way, there are transactions all over India and abroad also. So such things are there. Bank process are proper, but sometimes bank officer also involved in this case. Sometimes the department has called the bank officer also for statement purpose. Sometimes bank officer also be involved in this, making the wrong information and open the account for the illegal transaction purpose also.
Yeah, true, sir. Very true. And this was very much seen during demonetization period, wherein, the Swachh Bharat Abhiyan was connected with this Swachh Money Abhiyan. So, yeah. So there is one question from Raman Sharma, sir. He is asking whether putting the accused behind bars for money laundering offenses, is it a proper solution? Is there any other way?
Other way means, see, the trial will be there. Suppose matter has been filed by the ED, and after trial will be there, then after the impeachment will be there. Otherwise, any other law will be, ED will be, some law will be changed by the ministry, parliament, or then after law commission will be made further acts. In that 20 years imprisonment will be there. Such facilities will become, then is very good for the ED department and the country also. Such accused can be in the bar.
Thank you, sir. With this, I come to the last question.
Please, madam, please.
There is one question. As per AML Basel Index 2017, India ranked 88 out of 146 countries with a risk score of 5.58. That is money laundering and terrorism financing. What are the legal reform needed to improve our current stage?
I'm a special PP and conducting the matter in the court. And how can I say that? See, it is an economist of a government of India. The economist departments are there. They're planning, made the planning. They plan and they put the plan, with the ministry, and ministry afterward approval. They go to the parliament afterward go to the law commission, then after they'll become. Such things are there. If suppose, then after the development will be there. If suppose any development is there, you can also write direct to the ministry also, to the prime minister also regarding that we want to such and such a development we have to do. So it is welcome to all of them of India to give their opinion and give their opinion to regarding the development of the narcotic enforcement director, narcotic department, CBI to develop any new thing, add to new thing. All are welcome for that.
Yeah, thank you very much for your time, Mishra sir.
So nice.
With this, I hand over the mic to Professor Salim sir for the vote of thanks. Salim sir, over to you.
Thank you, ma'am. First of all, to start with, let me take this opportunity to propose of the formal vote of thanks. On behalf of KLE Society, KLE Law Academy, Belgaum, and KLE College of Law, Kalamboli, Navi Mumbai, I would like to thank you, sir, from the bottom of my heart for giving us this opportunity to listen to your valuable words and to get ourselves enriched from the knowledge that you have shared, sir. Sir, really speaking, let me come back something to vernacular. जैसा आपका नाम है भाग्य उदय, आपने हमारे नॉलेज का भी नॉलेज के भाग्य को भी उदय कर दिया, सर. Thanks a lot for that, sir. There were many aspects, I believe. So majority of our attendants are students who might not have been even aware of such things, sir. Like the way you started, sir, it was very enriching for us also to learn, especially for the teachers. You first gave the introduction with like how the ED or the CBI comes into picture. The jurisdiction, the scope, the matters, the limitations, appeals, punishment, seizure of property, attachment of property, the offenses, and almost each and everything was elaborated. And last but not the least, your conclusion was amazing, sir.
Yeah, take 10 days, 10 days I work on it. Then after I made it.
Really, sir, really, it is really enriching. The cases of Talwar case, Augusta Westland, ICICI Bank, Vijay Mallya, Chhagan Bhujbal, Nirav Modi, Mehul Choksi, and others.
Right.
See, these are the matters which have been regularly come into media.
Yeah, it's popular cases. See, other cases are there, but these cases are popular. So students tell me no, and other participants also will know that this type of cases are.
Yeah, sir, that's what I'm saying, sir. And thanks a lot.
Thank you very much. Thank you.
Us all from the bottom of heart and on behalf of my college.
Thank you.
I thank you for giving us this opportunity.
Thank you.
I would also like to thank our chairman, ex-member of Parliament Rajya Sabha, Dr. Prabhakar Korechi, for giving us
also this
opportunity. Sorry, sir.
Very thanks.
Yeah, so for giving us this wonderful opportunity to organize and arrange this seminar, and it is really a pleasure to have speakers like you, sir. I would also like to thank our general body chairman, Shri Mahantesh Kavatagimat, sir, who is an MLC in Karnataka and also the chief whip of the government of Karnataka. I would also like to thank Dr. Mallikarjun Naya, sir, who is the principal of our KLE Law College, Bangalore, and the director of the KLE Law Academy, Belagavi. Next, I would like to be very happy and take this opportunity to thank our beloved principal, Professor Dinkar Gitte, sir, to give this such a wonderful opportunity to enrich our knowledge and to polish our skills for new topics towards the new topics. I would also like to thank our organizing team members, Amrita madam and Pooja madam, for their wonderful arrangement of the sessions. I would also like to thank my colleague Srividya madam, who was the moderator for today, and our students who have taken so much of efforts. If you can see the chat box, sir, even now they are putting messages about the feedback forms, the coming event of tomorrow and all. From the bottom of my heart, I also thank my students. Last but not the least, I would like to thank all the participants who have been attending this session. And once again, sir, thanks a lot.
Thank you,
madam. Thank you.
Thank you, sir. Namaste.
Thank you, madam. Thank you.